Assalamualaikum, Professor Dr. Muhammad Fairuz. My name is Rosin bin Muhammad Sharif. I'm a Stat 9 student of Semester 1, 2023-2024 for the subject Business Ethics and Governance. Today, I'm going to present to you the assignment 4, specifically the answer for question 1. Question 1 consists of two parts, namely 1A and 1B. Okay, for question 1A, if the company does not have an internal whistleblowing policy, advise the caller on the next appropriate or alternative course of action he can take. What are the advantages and disadvantages of this alternative action? What the financial controller can do as a start, he should gather all the relevant information with regards to this issue. First, he can gather the handwriting piece of paper from the CEO instructing the clerk to register the sales. He can also get a copy of the fraudulent misstated financial statement that was used by the CEO and CFO during their discussion with the representative of the financial institution. Third, if possible, the financial controller can get a written declaration from the clerk admitting registering the sales upon instruction by the CEO and CFO. If possible, if it is a statutory declaration, probably it will be better. Then what's next with all the information that he has now? He can straight away go to the Company Commission of Malaysia and making a report with regards to this issue, as the Company Commission of Malaysia handles cases on corporate irregularities and breaches of company law under the Company Act 2016, specifically Section 540. However, if the financial controller is in doubt of what needs to be done next with all this information in hand, he can also seek a legal advice to understand his rights before disclosing this information. Okay, once he has understood what are the things that he need to be done, he can now go to the Company Commission of Malaysia to lodge a report on this case. Okay, as described in previous slide, for that particular type of case, the financial controller can report to the Companies Commission of Malaysia. For some other type of cases or different industry, a person can also lodge a report to the Securities Commission of Malaysia, as a Securities Commission can investigate improper conduct or other irregularities in the securities and futures market under the securities law. At the same time, a person can also make a report to Bank Negara Malaysia if something got to do with the financial institution or insurance company, as Bank Negara Malaysia can investigate on companies and individuals that contravenes the laws and regulation that Bank Negara administer. Okay. Lastly, a person can also lodge a report to the Malaysia Anti-Corruption Commission, as MACC handles cases on corruption, malpractice, and abuse of power by public official, for example, like bribery or false claim. Right. In Malaysia, for those who came forward to lodge a report to enforcement agencies, subject to meeting certain requirements, they can be protected under the Whistleblower Protection Act. Okay, the Act have a provision of in terms of ensuring the confidentiality of the information of the informant, and also making the informant not liable to civil action, criminal or disciplinary consequence, and also any act prejudicial to the outcome of the reaction disclosure that have been made. And another thing is the protection can also be extended to those that have connection or relationship to the informant. Okay, at the same time, under the Malaysia Anti-Corruption Commission Act 2009, there is also provision of protection when it comes to the confidentiality of information on the informant, and also other circumstances relating to the information. And also the identity should be concealed from view, obliterated or remove any source in evidence material that contain information leading to discovery of the identity of the informant, which is this is very important, especially during the court trial period. Okay, going to the enforcement agencies, there are some advantages and disadvantages. Let's look at the advantages first. First of all, there is a legal protection for whistleblower. As mentioned in previous slide, it's under the Whistleblower Protection Act or the provision under the Malaysia Anti-Corruption Commission Act. Because these acts, they provide uh, they shield those who reported misconduct from victimization or retaliation by their employers. Okay, at the same time, it can also increase accessibility, especially for those who feels uncomfortable uh, to disclose a potential misconduct through the company whistleblowing channel. With this, it can encourage more individuals to come forward with information about unethical practices. Third, it can also enhance confidentiality, allowing whistleblower to remain anonymous and protected from potential retaliation. This can lead to higher likelihood for employees to report wrongdoing. And the fourth one is also going to the enforcement agencies can contribute to regulatory or oversight and also assist the enforcement agencies in identifying and also addressing gaps in the existing regulation. This can lead to improvement in the regulatory framework to prevent future violation. Now let's look at the disadvantages of exposing irregularities to enforcement agency. First of all, the protection given to the whistleblower can be revoked if during the investigation by the authority it is discovered that the whistleblower is making the disclosure for fear of dismissal or disciplinary action. Okay, next will be retaliation from certain stakeholders, for example, from employers or fellow colleague, in the event that the identity of the informant is being exposed. Such fear can lead to hesitation by a person to come forward and report any misconduct. Uh, Third, there is also potential of future employability issues. Uh, Sadly to say that there are culture where certain companies may feel hesitant to employ a person who has who made a complaint to authority with regards to misconduct in his or her previous employment. Okay, next is the emotional strain. Um, it can be challenging, causing stress, anxiety, or even personal or professional strain on the whistleblower because under the Whistleblower Protection Act, the whistleblower will only be informed of the case status once the investigation has been concluded. So it may take some time for such investigation to be concluded. So there is an issue on that. Next is question 1B, which is recommend steps to be taken to establish an internal whistleblowing policy to the caller's company. The caller's, in this case, is the financial controller. Okay, there are 11 steps in establishing a company whistleblowing policy. Step one is the policy formulation. which it has to clearly state the purpose of the policy, emphasizing on the transparency, integrity, accountability, and the importance of reporting potential violation or concerns. The policy also requires to be aligned with relevant Malaysian law, for example, the Whistleblower Protection Act 2010, and also it requires the approval of the company's board of directors. Step 2 is the scope and application. It needs to specify the scope of the policy, for example, for employees, contractors, suppliers, or third party. And also it needs to define the type of wrongdoings that can be reported, for example, like bribery, abuse of power, conflict of interest, theft or embezzlement, misuse of company property, and non-compliance to procedure. The third is the reporting structure. It needs to establish clear reporting channel, for example, designated officer, hotline, or emails, and it needs to ensure confidentiality and protection for whistleblower. The fourth step is the eligibility to report. It needs to define who can become a whistleblower, for example, employers, contractors, suppliers, third party, or even public at large. Also, it needs to clarify the criteria for reporting, for example, like credible evidence or in good faith. Step 5 is the timing of reporting. It needs to specify the when the whistleblower should report. For example, immediately after discovery. It will also address any concern about delay or hesitation. Step 6 is on handling procedure. It should detail out the steps for handling reports, including investigation, documentation, and resolution. It needs to establish a mechanism for reporting to report and ensuring appropriate action. Lastly, it needs to ensure independence in the investigation process. Right. Next will be step 7, which is the external disclosure. It needs to define circumstances where external disclosure can be done to regulatory authorities, and also to state the compliance with legal requirement for external reporting. And next, under step 8 will be the protection measures. This is to ensure protection to whistleblower against retaliation and victimization. And the policy needs to outline the consequences for those who try to cause physical or emotional harm to the whistleblower. Okay, and then next on step 9 is the time limit and record retention. It needs to set a time limit for handling reports, establishing procedure for retaining records related to whistleblowing cases. Then we have step 10, which is the awareness of and training, and then where we need to conduct regular training session for employees, managers, and even the board members on the policy and procedures. And also we need to promote awareness through various medium communication, for example, like posters, company intranet, or company-wide communication like a blast email. Okay. Last but not least, step 11 is monitoring and review. It requires constant update on the policy to align with the legal changes and best practices. And also, we need to monitor the effectiveness of the mechanism in order to address any gaps that has been identified. Okay, that's all for my presentation on assignment 4, question number 1. Okay, thank you very much, Professor Dr. Fairuz.